Hello everyone and welcome back to your channel Lawpedia. So first of all, wishing you all a very happy new year, and starting this new year, that is 2021, first few videos that you will be getting on this channel would be pertaining to the important judgments delivered by Supreme Court in the year 2020. In one video, we'll be covering Constitution Bench judgments. In the next video, we'll be covering the criminal law judgments. The next would be civil law, and then we'll be covering certain important judgments delivered relating to the field of education by the Supreme Court of India. Next, we'll be covering the important judgments related to family law, and lastly, we'll be taking up the judgments delivered in suo motu cases by the Supreme Court in the year 2020. I hope आपको basic structure clear हो गया है, और for the videos आपको 4 to 5 videos मिलेंगी pertaining to your judgments delivered by Supreme Court in the year 2020. Let's quickly get started. इस वीडियो में we'll be covering Constitution Bench judgments. One of the very important question that comes up over here is, what is a Constitution Bench? Before moving forward in understanding, आपको ये basic term clear होना चाहिए कि what is a Constitution Bench. So generally, if you'll observe, Supreme Court judgments are heard by a 2-judge bench, which is a divisional bench, or a 3-judge bench as well. However, there are certain exceptional circumstances under which the Constitution Bench is constituted, that comprises of your 5 judges to hear a particular case. Certain important factors जो आपको पता होने चाहिए in case of Constitution Bench, when we will refer a case to Constitution Bench, or when will a Constitution Bench be constituted. Firstly, if the case involves substantial question of law pertaining to the interpretation of Constitution. So, ऐसा कोई substantial question of law है that requires you to interpret the Constitution of India, then you may refer the same to the Constitution Bench. Secondly, if the President has sought the Supreme Court's opinion on a question of fact or law under Article 143 of the Indian Constitution, then also Constitution Bench can be constituted. Thirdly, when 2 or more 3 judges bench of the Supreme Court have delivered a conflicting judgment on the same point of law. Now 2 or more 3 judge bench ने conflicting judgments दी हैं. So now we create a 5 judge bench in order to make the area of law completely clear. Fourthly, if a later 3 judge bench doubts the judgment delivered by a previous 3 judge bench, and then we decide to refer the same to a 5 judge Constitution Bench. So I hope you're absolutely clear with some of the factors in which we constitute, or in which we form a Constitution Bench comprising of your 5 judges. There are in total 11 Constitution Bench judgments given by the Supreme Court of India in the year 2020. We'll be progressing and understanding the very first case law for our video, which is Sushila Aggarwal versus State of NCT of Delhi. So ये case basically deal करता है protection under anticipatory bail should not be fixed for a limited period of time. So this was the basic theme of this Constitution Bench judgment, whereby the court held that protection granted to a person under section 438 of the Criminal Procedure Code. Please be aware or read that section 438 of your Criminal Procedure Code deals with the provision of anticipatory bail. That should not invariably be limited to a fixed period and should be in favor of the accused without any restriction on time. So when we are granting anticipatory bail, जब भी हम accused को, when he is apprehending arrest, let's say a person A is apprehending a arrest, he applies to the court for anticipatory bail. That means we are giving a sort of a relief to the person. Now he is scared that he may be arrested. That's why वो एक एप्लीकेशन मूव कर रहे हैं कोर्ट पे टू सीक एंटिसिपेटरी बेल. सो अगर ये इतना इंपॉर्टेंट प्रोविजन है, इट शुड नॉट बी लिमिटेड फॉर अ फिक्स्ड पीरियड ऑफ टाइम एंड शुड बी इन फेवर ऑफ द अक्यूज्ड. नाउ further, in this particular case, court held that life or duration of an anticipatory bail order does not end normally at the time and stage when the accused is summoned by the court or when the charges are framed, but can continue till the end of the trial except in special or peculiar circumstances. इसका क्या मतलब है? So this basically means that when we are granting the anticipatory bail to a particular person, it does not normally end when the accused is summoned. So वो तब नहीं end होगा, not when the charges are framed, वो तब नहीं end होगा. When will it end? It will end only with the end of the trial. That's how wide the provision of anticipatory bail is, except in certain special or peculiar circumstances. यहाँ पे in this particular case, court reaffirmed the principle of Shri Gurbaksh Singh Sibia versus State of Punjab that was delivered in 1980 by the Supreme Court of India. The fundamental question in our case of 2020 was whether the protection granted to the person under 438 should be limited to a fixed period so as to enable the person to surrender before the trial court and seek regular bail. Basically इसमें anticipatory bail के nuances को court ने judge किया है. If you want to read the judgment, it's a very well written judgment which talks about various aspects of your anticipatory bail provision under section 438 of the criminal procedure code. ये बताता है कि उसका time limit कितना होगा, under what circumstances can the time limit be reduced, is there any fixed period for anticipatory bail, and what is the basic crux of the same. So whenever you're making an application to the court for grant of anticipatory bail, the application must be clear. It should state the story from the side of the accused. Now, court while deciding the anticipatory bail application will definitely see the nature as well as the gravity of the offence. These are the basic factors that generally court sees in terms of granting such bail applications. Let's move forward to our next judgment. Now, this was another important judgment delivered by the Supreme Court, जहाँ पे Supreme Court ने कहा है कि Supreme Court can refer a question of law to a larger bench when it is exercising its review jurisdiction. This judgment was delivered pertaining to your Sabrimala case, whereby the 9-judge bench hearing the Sabrimala reference held that Supreme Court can refer a question of law to a larger bench while exercising its review jurisdiction. इसी केस में the court also framed 7 questions which are related to Article 25 and Article 26, which will now be heard and decided by the 9-judge bench. Now, the next important judgment delivered by the Supreme Court was in case of Pawan Kumar Gupta versus State of NCT of Delhi, which was another very crucial judgment given by the Constitution bench, dealing with curative petition and stay on execution of the 2012 Delhi gang rape convict that was dismissed by the Supreme Court. So the court dismissed the curative petition of a death row convict in 2012 Delhi gang rape case and orally rejected the application for stay on execution. And later on March 20, in midnight hearing, the court dismissed the final plea against rejection of mercy petition of the convicts by the President of India, and afterwards at 5:30 a.m. on the morning of March 20, the 4 convicts were hanged to death at the Tihar jail. So this was another very fundamental judgment given by Supreme Court, whereby the curative petition and the stay on execution of the 2012 gang rape convict was dismissed in 2020. Another important judgment is SARFAESI Act will be applicable to cooperative banks as it does to the commercial banks. This was delivered by Supreme Court in Panduranga Ganpati versus Vishwasrao Patil in the year 2020 itself. So the Constitution bench held that Securitization and Reconstruction of the Financial Assets and Enforcement of Security Act 2002 will be applicable to cooperative banks, which are banks under the Act. So in this particular scenario, you must understand basic that what is SARFAESI Act. So the 2002 Act basically empowers banks and other financial institutions to directly auction residential or commercial properties that have been pledged with them to recover the loans from the borrowers. So this was basically the act that gave the banks the powers to go ahead and auction the properties that is pledged with them, and banks can seize and sell the collateral properties of the defaulters after giving a 60 days notice or within 60 days of demanding repayment without the permission of court. So 60 days term prescribed किया गया है for the banks to provide notice to the borrower, and after this the lender can take possession of the pledged asset of the borrower. Now, this particular recovery mechanism established by the Act saved a lot of time, saved a lot of money, saved a lot of processes, because otherwise all these recovery mechanisms would have been done by the means of civil litigation. So अगर ये interesting mechanism आपका commercial banks को भी available है, so this must be available for the cooperative banks as well, so that they can also easily recover their dues. Let's quickly move to the next judgment, which is your Chebrolu Leela Prasad Rao versus the state of Andhra Pradesh. इस judgment में कोर्ट ने ये कहा that the government order that was dated 10th January 2000 issued by the erstwhile state of Andhra Pradesh providing 100% reservation to scheduled tribes candidates in the post of teachers in the schools located in the scheduled areas itself is unconstitutional. That means if you're providing 100% reservation to scheduled tribe candidates, where are the other general candidates? What about Article 14? What about equality? What about the other aspects of the constitution? So though reservation important hai, it cannot go on to the extent of 100%. You can very well provide reservation to a certain limit, but it cannot be 100%. Further, the court also concluded that, please omit this, there was no reason for the state to resort to 100% reservation. So that means there is no particular reason. Reasonable excuse is also there. When you have a reasonable factor, you can show that why we have discriminated. Court may consider it under Article 14, but if you do not have any reasonable factor to show the court, why will court accept your 100% reservation? So this was the 2020 judgment. Let's quickly move to the next judgment. The next important case is Mukesh Singh versus State Narcotic Branch of Delhi. So in this case, court held that accused under the NDPS Act is not entitled to acquittal merely because informant was the investigation officer. Case dealt with the basic principles of natural justice and the basic principle of fairness that has to be followed in a particular case. Now, court ने exactly क्या state किया? Court stated merely because the informant is an investigator, by itself the investigation would not suffer the vice of unfairness or bias, and therefore on the sole ground that the informant is the investigator, the accused is not entitled to acquittal. The matter has to be decided on case-to-case basis. So court basically stated that, let's say I am an investigating officer and I am the informant. So I am both the investigating officer and I am informant against a person A who has been charged in the NDPS Act. So the basic investigation which I have conducted will not suffer from the only factor that I am the informant. Court will see the other relevant factors and और बहुत सारे scenarios होंगे जो court को देखने होंगे. For all of you who are not aware about it, the NDPS Act 1985 is the primary legislation for dealing with drugs and their trafficking in India. And it has various provisions to punish the manufacturing, sale, possession, consumption, use, transport of banned drugs. So the next important judgment that you can have a look of 2020 will be Tamil Nadu Medical Officers Association versus Union of India. So in this particular case, the important factor was that states and not the Medical Council of India have power to make reservation for in-service PG candidates in the NEET courses. The Constitution Bench held that Medical Council of India has no power to make any reservation for in-service candidates in postgraduate medical courses in states, and that only states are allowed to grant the benefit of reservation of seats to in-service doctors in the NEET PG courses. So basically, court ने यहाँ पे elaborate किया that Medical Council of India will not have any particular role while deciding the reservation for the PG candidates. Basically, states will decide what is the quantum and the amount of reservation to be given in such cases. Now, the next important and interesting judgment that we can have a look would be New India Assurance versus the Hilli Multipurpose Cold Storage Private Limited. Very important factor was Consumer Forum has no jurisdiction to extend the time beyond 45 days for opposite parties' version. Now, very specific judgment, not a general factor. You can go ahead and read the Consumer Protection Act and the various factors stated, and you'll be able to better understand. Apart from that, the very specific aspect dealt in this particular case was the court held that district forum has no power to extend the time for filing the response to the complaint beyond the period of 15 days in addition to 30 days as given under your section 13 of Consumer Protection Act. It further held that commencing the point of limitation of 30 days under section 13 of the Consumer Protection Act would be from the date of receipt of notice accompanied with the complaint by the opposite party and not mere the receipt of notice of complaint. Firstly, section 13 30 days, additional period of 15 that totals up to 45 days. District forum की jurisdiction यहाँ पे over होती है that it cannot extend the time limit beyond 45 days for you to file response to the complaint. From what time you will calculate the 30 days? It will be the date of receipt of notice accompanied with complaint. So both the factors, notice and the complaint. So this was another important judgment. The next judgment would be in case of Dr. Shah Faesal versus Union of India. So in this particular case, Article 370's reference to a larger bench was denied. So a 5-judge bench of the Supreme Court held that there is no need to refer to a larger bench the petition challenging the presidential order that were issued in 2019 to repeal the special status of Jammu and Kashmir under Article 370 of the Constitution. So the basic arguments was कि एक 1959 की judgment है and एक 1970 की judgment है which is conflicting. So for the same, the reference should be made to a larger bench and the larger bench should also decide the validity of the presidential order issued in the year 2019. So this was denied by the court. And that's it for today's video. So I hope you are absolutely clear with the various constitution bench judgments. We can clearly see, despite the fact that country was in a lockdown mode, we had all the COVID fears and the pandemic factor going on, the Supreme Court of India's Constitution Bench was able to deliver certain important judgments that we must all be aware about. So I hope you understood. And again, for any legal help, please write them in the comment section down below, or for any doubt that you must be having pertaining to the video today or any other prior video, you can definitely mention them in the comment section down below. And please share the videos and subscribe. Until then, please stay home and please stay safe and keep learning.